I think in film, everybody's always vying for power and control. I think that this is probably the most intense situation I've ever been in film. He was one of the few directors I've worked for that was very kind and respectful. In my opinion, I find it very hard to believe the allegations against him. And considering his mission statement about the film and him genuinely pitching that he was doing this film to help young women, I just find it hard to believe.
Sometimes in legal battles, especially when dealing with narcissists, lawsuits aren't really about justice, they're about silencing people. Narcissists will often use litigation to punish or quiet those who speak out against them. This includes anyone from critics to journalists, YouTubers, bloggers, anyone with a platform. In this case, Blake Lively appears to be doing just that, turning her attention toward Justin Baldoni's legal team and now also targeting creators online. Why is she doing it? Here's what I suspect. Ever since Justin's case was thrown out, Wayfair and those connected to it have focused entirely on one legal matter. Vanzon Incorporated versus Doe defendants, filed in New York State on September 27, 2024. The lawsuit used basic claims like breach of contract and damage to reputation based on third parties allegedly releasing unfavorable information. Yet, they only subpoenaed one entity, Jones Works, and specifically sought data from Jen Abel's phone, who used to work there. That subpoena was issued on October 1, 2024. Based on court records just revealed, Ryan Reynolds now claims to be the owner of Vanzon Incorporated. There are actually two companies with that name, one in New York and another in California. The California one was originally defunct but was revived in 2021 by Blake Lively. However, it was forfeited and can't legally operate in California due to outstanding tax and legal issues, civil lawsuits, unpaid wages, and even Federal Trade Commission involvement over shady marketing tactics. Blake's name is still associated with it, though. That California entity is technically a foreign company, with the primary registration in Delaware. Meanwhile, Ryan set up Vanzon Incorporated in New York in 2019, not as a foreign company but as a local one. So now we've got two different Vanzons, tied to the same address, but with different tax IDs, one linked to Blake, the other to Ryan. And Ryan claims his version of Vanzon is the one that subpoenaed Jones Works for Jen's phone data. So, what's going on here? I believe they're panicking, especially after TMZ dropped a story that only Blake's team could have leaked. The article claimed that Blake subpoenaed 3 prominent content creators who are allegedly being fed info by Wayfair. These creators are Candace Owens, Andy Signore, Popcorn Planet, and Perez Hilton, all of whom are independent commentators. Now here's where it gets strange. Candace Owens denied being subpoenaed. I spoke to Perez Hilton, and he sent me his video response stating clearly that he hasn't received anything. He questioned the truth of TMZ's report, especially because today is the court's deadline for substantial production of documents. In that video, Perez also noted something important. No new subpoenas have gone out since around May. To recap, journalists from Daily Mail and Page 6 were subpoenaed in April. Justin's lawyers received theirs in May. The bulk of subpoenas were issued in February and March. So even if someone got served now, there's barely time to respond. Blake got her headline, though, implying these creators are part of a coordinated effort with Wayfair. This mirrors what happened with Shasty Flaw, who messaged me today asking if I was subpoenaed. I wasn't. Neither was she. Yet she's been publicly accused of being part of a smear campaign for months. The Wayfair side has requested documents from others showing communication with her, yet she herself hasn't been served anything. Instead of directly engaging people like Shasty, Blake is focusing on high-profile creators, people who generate buzz and emotional responses. This feels intentional. Technically, she could still subpoena them. The final deadline for discovery is August 14th. But realistically, no one should be subpoenaed after late July, because they wouldn't have time to respond, object, and prepare. Serving subpoenas now is already cutting it close. If Blake does try, all parties are likely to object. So why now? Because the focus has shifted onto the weaknesses in Blake's case, especially around the sham lawsuit involving Vanzon. If proven, this could show that Blake and Ryan misused the legal system, potentially leading to lawsuits for abuse of process, privacy violations, and maybe even criminal charges. Most critically, it could lead to their evidence being thrown out. Last week in court, Blake admitted she got information from Jones Works via the Vanzon lawsuit. But Jen Abel has argued in a motion to compel that the Vanzon lawsuit was fake, a strategic move to grab private data without a proper case or notice to the affected parties. In the U.S., people have a right to object to subpoenas. Judges limit what can be requested, and not everything is fair game, especially private or privileged material. When Blake tried to subpoena phone companies, the judge already denied it, calling it an invasion of privacy. Yet, the Van Zandt subpoena went much further than what the phone companies were asked for. So logically, the judge should also view that subpoena as overly broad and improper. But that's only one piece of the issue. Other flaws in Blake's approach could also invalidate the evidence. For example, she's targeting creators now because she's trying to discredit them, to silence anyone criticizing her. If people believe that Perez or Candace are part of a smear campaign, they might stop trusting them. But here's the thing, she can't prove a coordinated digital smear campaign. She can't trace it. So now she's going after those just talking about the case, even though the case is public. This tells me she's trying to destroy their credibility to protect herself. She might also fear that Jen Abel's motion to compel could destroy her case. In civil court, parties whose data is being subpoenaed must be notified. Failing to notify someone violates due process, and that could make any evidence collected inadmissible. In this case, Jen Abel wasn't warned that her former employee was handing over sensitive data. Even though it was a company phone, Stephanie Jones had no legal right to transfer private info without notice. The problem also extends to how the discovery was shared. Blake has said repeatedly that she got the evidence through a legal subpoena. But she didn't. Van Zandt Incorporated got it through the sham lawsuit. Blake was not part of that action. Federal rules state that discovery cannot be transferred to a different case without court approval. So for Blake to use the Van Zandt material in her case, she'd need to subpoena Van Zandt, not just take it. By skipping that legal step, she broke the chain of custody. Now there's talk that metadata is missing, which makes it even harder to prove the data was obtained properly. If you can't verify the source, the content, or how it was stored, then the court can't rely on it. Using lawsuits as a tool to collect evidence and then dropping the case is also frowned upon. Courts don't like litigants abusing the process to fish for information outside proper boundaries. On top of that, Blake may have violated electronic privacy laws, including the Stored Communications Act and federal wiretapping laws, by accessing iCloud or iMessages. If this all pans out, they could face sanctions, motions to exclude evidence, and protective orders to prevent the use of any improperly obtained data. They could also be sued for invasion of privacy and misuse of the legal system. What Blake doesn't want is people focusing on how she got her evidence. I spoke with a lawyer who explained that if a judge knowingly allows this sham process, it raises serious ethical concerns and is likely to be appealed. I asked what would happen if the judge says the phone belonged to Stephanie, so there's no privacy issue. The lawyer said, then why the need for a subpoena? If Stephanie truly owned the data, she could have just handed it over. The fact that she needed a court order means she was bound by confidentiality agreements, especially with Wayfair. Even if Jen wasn't the one who directly sent the communications, it was still her data. And if Blake's team got that data through Van Zandt, a company linked to Ryan Reynolds, it raises even more legal red flags. Many attorneys I've spoken to believe Wayfair should appeal the case's dismissal. Since the case was thrown out with prejudice, meaning they can't refile, it blocked their chance for justice. If they can prove that misconduct occurred and the court didn't allow discovery, they have strong grounds to challenge the dismissal. One big issue, the judge said Blake was protected under litigation privilege, based on her CRD complaint. But a lot of her alleged wrongdoing, like defamation and interference, happened before she filed the lawsuit. That means a jury should have decided, not just a judge. He also ruled that Ryan couldn't be blamed because he was simply backing his wife. But then, how do you explain his company subpoenaing Jen's phone under claims that she breached his business contract? Blake and Ryan seem desperate to keep the case alive because if it gets thrown out, they'll be seen as fraudulent and having brought a frivolous claim. She did her victory lap before discovery even happened. If her case was so solid, she'd have real evidence, not just accusations of interference. Now she's even accusing Justin Baldoni's law firm, led by Brian Friedman, of being part of the smear campaign. In a California court filing, Friedman's lawyers argue that Blake is overreaching. She wants to access their files because of statements made to the media, but lawyers are allowed to speak publicly for their clients. Blake's legal team claims they need billing records and mobile phone logs for all employees. The court is being asked to reject the request for being overly broad and intrusive. Friedman's team says, if she wants to know what content creators said, ask the content creators, not the law firm. Plus, a lawyer defending their client in public doesn't open the door to digging through privileged files. Blake's entire approach is based on a hypothetical theory, that Wayfair coordinated with creators to retaliate against her. But even if that were true, that wouldn't justify violating legal protections. She's trying to prove content creators were paid or fed info, but hasn't shown any proof. I haven't been paid. I haven't spoken to anyone who has. Most people talking about this are doing so based on court records and public statements, including hers. At the end of the day, I think Blake and Ryan are panicking. They know their case is falling apart, and they're trying to shift the narrative before it all collapses. What do you think? Drop your thoughts in the comments. Don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss an update. Thanks for watching. Bye guys.